We're continuing our discussion on intellectual property, and we are getting to one of the forms of intellectual property that you interact with the most. In fact, you probably interact with it all day, and I think you're going to find some surprises in this material. So that form of intellectual property is copyright. And copyright's really interesting to me because it is about works of authorship, particularly original works of authorship, and we're talking music, movies, art, poetry, writing, all the stuff that we create. So just think about things we author, and we're going to talk in some detail about that. Now, one of the things I like to ask when I start the section on copyright, especially if I'm teaching this in an open class, which we're not now, is I ask if anybody owns any copyrighted material. I have asked this for 5 or 6 years, once or twice a semester, so we're talking 10 to 12 times. I have never had anybody raise a hand that nobody owns any copyrighted material, and that is absolutely false because you all own copyrighted material. In fact, you probably created copyrighted material today because anything that you create that is a work of authorship is technically your copyright. You own it, and if somebody copies it, you can enforce it. So if you are taking notes right now and I came up behind you and I took a photo of them, I just violated your copyright. So you record a song, you draw a doodle on your notebook, that is yours. You own it. You own the copyright to it. You do not have to file for anything. We're going to talk about this later. You do not have to file for anything. It is yours. So let's just quick define what a copyright is. Besides it being an original work of authorship, there's one thing you need to know in particular, and that is that original work of authorship must be fixed in a tangible medium. It must be fixed in a tangible medium. If you have the idea for a painting, okay, you tell a friend about something you want to paint, and that friend goes and paints it. You did not fix it in a tangible medium, and so they have the right to take that idea. You have to paint it or sketch it out or somehow fix it in that tangible medium, like your art or your recording, digital or physical. But you need to fix it in a tangible way. So this is actually pretty interesting, like how people do this. Especially, I lived in California, and you go into like a Starbucks, and everybody be in there writing their screenplays, right? So one of the risks people had is that they think they'd have a great screenplay idea, and that they'd go try to meet with a film exec, and then they're all worried that someone's going to steal your idea, okay? And then they're going to go make that movie. So what they do is they write out their screenplay, their idea, and then they print it, put it in a stamped first-class envelope, and they mail it to themselves. And then you put some kind of tape or seal over the so you can tell the letter's never been opened, right? And so that's their way of proving that they fixed it in a tangible medium. They wrote their screenplay idea out, and then they've got that documented stamped date from the Postal Service. So it is all going to be about fixing things in tangible mediums, and we're going to look at some examples of this. I want you to let's think about music for a while, and I want you to think about Vespers, right? Let's say that you play in Vespers, and you've got the idea for an original worship song, and you're meeting with your with your Vespers group, and you decide to play this song at Vespers. Now, it's never been written down. You've never recorded it. You just are like, hey, I've got this idea, and I want to play it. Join me. And you're sort of jamming on stage, right? And then you got this great song, and Chris Tomlin is up in the audience. He somehow happened to show up at Bethel, and he is listening, and he's like, that's a sweet song. I'm going to use that as my next worship song. And he goes and he steals it. Chris Tomlin steals your song. You want to go and sue him for copyright? Did you have a formal copyright? Do you have any rights to that song? If you didn't write it down, you didn't write down the chords, you didn't write down the lyrics, you didn't record it, you have no rights because you never fixed it in a tangible medium. Chris Tomlin can just walk away with your song. If same scenario, if you had written that song down, if you had recorded it, if you took out your iPhone and you hit the record button and just recorded it into your iPhone, then you have fixed in the tangible medium, and when Chris Tomlin steals it, you can go sue him and say, hey, I had that song before you did. Here's the proof. I fixed it in a tangible medium. Here's the audio file, and you would have the ability to collect some damages for copyright violation. So next time you go to a concert, one thing you'll notice is that if you look back by the sound booth, they always have a microphone back there, and they often have some kind of video camera, these days like a webcam sitting there. And the reason they do that is because they are fixing that event, those songs and that scene in a tangible medium. So, they don't want you to record, they usually don't want you to film concerts and then go and put it up on YouTube, right? Well, now people kind of can because of, phones. And so it's sort of a thing now. But it used to be that back when I was younger, they'd like search you and make sure you didn't have any kind of video camera apparatus because it was a big deal. Anyway, so they're usually recording the audio and the video at the back just to have it fixed in the tangible medium so that they can go and stop, prosecute bootleggers. Okay, so remember, fixing in a tangible, physical way is what's important. And if you have good ideas, songs, art, photographs, right, scenes that you want to photograph, you need to fix them. And the more you can document that date, the better. Let's say you come up with some clever thing you want to skywrite, right? You've got this design or this little phrase, and you want to skywrite it over Bethel. Do you have the copyright if someone goes and takes a picture of it or copies that and starts using that phrase? No, probably not, because skywriting is not a tangible medium. It just disappears. So think about things that are really lasting, and they can't just naturally disappear. Right? Here's kind of a silly example, or it's an interesting example. So, this guy was on safari somewhere. A monkey got a hold of his camera and took a selfie. So the monkey was playing with the camera. It's like a baboon or something, but the monkey, we'll call it a monkey. This monkey took a selfie. The photo went viral, and Wikipedia posted the image as public domain. The camera owner, the guy who had gone on safari, took his camera, the monkey stole his camera. The camera owner sued, or he's asked for cease and desist, and said, Wikipedia, take it down. This is not a public domain image. I own it. So, does the camera owner have copyright? Ooh, well, did the camera owner fix it in the tangible medium? No. If the camera owner took the picture, that'd be different, but the monkey took the picture. Okay, so does the monkey own copyright? Well, no, the Copyright Office does not give copyright protection to animals, nature, or plants. And so this monkey selfie is public domain, even though it was taken on this guy's camera that he owns. Now, what about if you set up a GoPro on a dog and had the dog run around? Is that then public domain? This is where the technology and the law get kind of interesting, is that we have these variations on the story. So what would happen in that situation? Well, I would argue, again, I don't know how it would be resolved, but I would argue that you set up the camera and you set up the situation to put it on the dog, and then had, so essentially you're taking the image and the dog is just the medium for the image, as if you had put that on a remote control car or something and drove the camera around, or a drone, right? I think if this gentleman had set a timer on his camera to just start taking pictures every few seconds, and it took a picture of the monkey, and the monkey wasn't the one who pressed the button. I think that would be a different story. So because the monkey, out of its own autonomy, took this picture, it is public domain. So you will often see this symbol, the copyright symbol. You'll see it at the bottom of web pages, you'll see it in the front of books, you'll see it on images. It's really interesting. You can use this freely. If you believe your work is copyrighted, you can use this. You don't need to file anything, you don't need to do anything, but you want to put this because this gives notice to people that this thing that you are claiming that you own it. So you create a website. If you are a photographer, they often do watermarks with the copyright. You build a website, you put copyright at the bottom. If you've got a song or a poem that you publish, you'll want to put this on there again. You don't need to file anything. You can just use it. It's your way of giving people notice that you have copyrighted material in this. Now, you can file for a copyright. There is a process for that, and it is something that is necessary to get certain types of damages later. And even if there's an issue, you can sometimes go and file for this later before you have a lawsuit. I wouldn't worry too much about that, but know that you can file. Filing gives you the ability to get financial damages, but you can typically stop people, get an injunction without having to file anything, and just using this copyrighted symbol and fixing it in a tangible medium. Duration of copyrights. So there are just a couple things I want you to know here, and this is a little confusing. So I really want to focus on post 1978. So anything that's 1978 or later, essentially today, is the life of the individual who fixed the expression in the tangible medium, their life plus 70 years. So if you write a book, your great-grandchildren will probably have some rights to it because the copyright is for your life and 70 years beyond that. Now, pre-1978, it was 95 years from first publication. So that's good to know if you are, I write books and I sometimes grab, quotes and material from, I often do from material that's older than that publication date, and so I'm often looking at that. So I'm not too worried about you knowing that for the midterm or anything. I really want you to focus on that later 1978 life plus 70. Now, one other thing I want you to know is that works for hire are like businesses that own copyrighted material. So I work for a business, I create works, I create copyrighted material for that business. It is 95 years from the publication or 120 years from creation. So it's not based on your life, it's now based upon just the publication. So 95 years from publication when you first used it in a public setting, or 120 years from creation, whichever comes first. So know that individual life plus 70, and then the 95 years from first publication, or 120 years from creation for works made for hire. When we have violations of copyright, we call it copyright infringement. And there are three things that you need to prove in order to prove copyright infringement. The first is that the defendant had access to the copyrighted material. So they would have known or would have been able to find it or should have been able to find it. So if you copyrighted a song, if you created a song in your dorm room at Bethel and someone in Australia writes exactly the same song out of a coincidence, there's probably not infringement because even though you had it first, there's no way that they would have known or seen it based upon the circumstances, so there was no access. So in that case, we don't fine for infringement. Second is that the defendant engaged in enough copying that the work does not seem coincidental. Okay. So again, the circumstances are such that this isn't a coincidence anymore. We'll look at some examples of this coming up. And then finally, the real key to this is substantial similarity. There is substantial similarity between the two works. So a couple examples. Shepard Fairey, that street artist, he did a very famous Obama poster where he had hope and progress, these things. And so he did this, and then the Associated Press sued him saying, you based your image on our copyrighted Associated Press photo. Okay, so did Shepard Fairey have access to copyrighted work? Sure. The Associated Press had published these photos. They were available in the public sphere, so it seems, and if you did a Google image search, you could find it. It seems like Shepard Fairey would have had. There's no way he could say he had never seen it, right? Associated Press is too broadly disseminated, so absolutely there's access. Is there enough copying? Well, it sure seems if you look at the tie and you look at the neckline and the shadows and the tilt, everything, there is enough copying. It's an identical looking angle on President Obama. And then finally, is there substantial similarity? Now, even though it's a little different, it still looks like there is substantial similarity. And I think you would look at this, kind of what's your gut check on this? And you say, yeah, it's the same. It's just colored differently. Okay, so it seems pretty clear that there is a strong case for copyright infringement here. Now, Shepard Fairey countered and said, hey, President Obama looks like this in a lot of pictures, and so how can you say I absolutely copied the Associated Press photo because I could have used a different photo, and here's one that came from public domain, and look how similar it is. And so his argument was lots of people could have taken this picture. It's a common angle. Why would you think that I used that Associated Press photo and only that one? So they ended up settling the case out of court. So we don't know how it would have been resolved, but it's an interesting, at least, lawsuit for copyright infringement. Now, I'm going to show you several interesting videos that involve Vanilla Ice, Robin Thicke, Lecrae, and asking this question of how much substantial similarity does there have to be to have a copyright situation. So you're going to see musicians here who copyrighted, there were copyrighted songs, and presumably people, these other musicians copied it, and we will get to, we'll discuss more of this when we get back. So you're going to have several videos so this is part 1 of copyright. There's going to be a part 2, and I want you to watch these several videos that I'm posting, YouTube videos between that. And the final one that you're going to see is really asking the question of, okay, so if there's substantial similarity, and we have substantial similarity in songs, is there ever a point where, if you play guitar, you know that every song is based on 3 chords, C, D, G, right? I mean, most songs are. 80% of the songs are C, D, and G, or some variation of that. Maybe 1 or 2 other chords and E in there, right? Because that's just a key that people like to listen to. So how many variations can you really have? And is there a point where copyright violation of music is moot because there's not being new music? It's impossible to create new music, and it's all just going to be copies of each other. So you'll see some examples, and then also ask that question, and join me on part 2.